Welcome, John. I think we can start now. Welcome everyone to this series on debates on human rights in human rights research and advocacy, movement building, as well as organizational leadership. She recently joined the ACPF from Amnesty International, where she was regional director for East Africa, the Horn, and the Great Lakes region. She has advocated for protection and promotion of human rights in complex regional conflict situations and post-conflict environments. She has also worked in restorative justice for survivors of sexual violence, torture, and other human rights violations. I am really proud to welcome her as our first speaker in this series. We couldn't have a more passionate advocate for the rights of African peoples, including specifically those of women and children. So it is my pleasure this afternoon to welcome Joan to this series. Before she takes the floor, I just wanted to highlight a couple of housekeeping arrangements. I would like to request, if possible, if you could keep your microphones as well as your video off when she speaks, in order to secure the bandwidth. But also, once John speaks for about 30 minutes or so, we will enter a Q&A session. And for this, I would like you to write your name in the chat if you'd like to ask a question. And then we'll take those questions in the order of the names that are appearing in the chat. I think with that, I'll hand over the floor to John. John, welcome to this series. Like I've said, really, really honored to welcome you. We couldn't have a better advocate for children's rights speaking to us this afternoon. Welcome. Karibu.
Thank you, Asante. Thank you very much, Thoko, and thank you to everybody who has made this possible. And I really want to start by saying what a glowing introduction and privilege really to be here to share my insights and those of the African Child Policy Forum as part of your series that actually excites me very much, and I hope I will continue to listen to in the coming weeks and months. So to my audience, I will start by introducing the African Child Policy Forum, and then I will go into my presentation, during which I will share my So the African Child Policy Forum, without going too much into the details, is an organization that's Pan-African in spirit, Pan-African in its work, and also in its mandate, in that we are founded to advance the rights and well-being of children. And I want to emphasize the element of well-being, because in an African context, the conversation between what is rights and what is well-being is quite a tense one, especially when it comes to certain rights. And so we say, over and beyond rights, we are talking about well-being of African children. And so what ACPF does in advocating for the rights and well-being of African children, guided by the African Charter on the Rights and Welfare of the Child and the Convention on the Rights of Children, is to undertake research that drives our advocacy for policy and legal reforms. And using this research, really, we engage with governments, we engage primarily with national level governments and with the African Union through the Africa Committee of Experts on the Rights and Welfare of Children, supporting them technically and also helping them to advance their own goals and objectives in line with Africa's Agenda for Children, which is now Africa Agenda 2040, but also more broadly within Africa Agendas 2063. So we are very much aligned with what's happening on the continent, and that's the thrust of our work. So ACPF is based in Addis Ababa. We have been in existence for the last 18 years and can boast of quite a few successes. But for the purpose of this audience. I will not boast of those now, but I will go on to share with you my presentation that looks at addressing the rights of children as far as the justice system goes. And my presentation, my discussion today is entitled Improving Access to Child-Friendly Justice Systems on the African Continent. I will probably take about 25 minutes from now going forward. So allow me to share my slides, to share my screen. There we go. Good. Okay. So welcome, ladies, gentlemen, guests, to my discussion this afternoon. And I will dig in by first asking ourselves, what exactly is a child-friendly justice system? And this really is a justice procedure that specifically is tailored to the needs of children who come into contact with the law, children who come into contact with either the criminal law, legal system, civil law, administrative, or in the African context, customary law. We cannot forget that there is the customary, sometimes called traditional, informal, alternative justice systems, which play a big role on the continent. So it is really trying to see how do justice procedures respond to the needs of children who come into contact with the different justice systems. And that's what I'm going to be looking at. How can this be friendly? As a broad statement, child-friendly justice requires more than just laws that make provisions for children. These laws must go on and be responsive to the rights of children and reflect the child norms and principles. Principles like the best interests of the children, do no harm, child participation. All these must be reflected when a justice system is friendly and responsive to children. And that is when it then allows children to seek redress and get remedies. The importance of looking at this from a very early age for children is, we all know on the African context, the enormous challenges in terms of social and economic structures and systems. And without even speaking about the COVID challenges, there are challenges in social protection systems. And this means that children can very easily fall between the cracks, between the gaps of a legal system, if the system does not focus and identify their unique vulnerabilities. I will share with you the key elements of a child-friendly system, justice system, so that we can then see how do we address this and how do we advance this. And this is for us to begin to reflect where we are as African countries as far as responding to the needs of children who interact with the justice system. I will not go through all of them, but I want to highlight just 4 of these. And one is the importance of child participation, the importance of the justice system being sensitive and responsive to the child's developmental stage. How a 5-year-old, how an 8-year-old, and how a 17-year-old will be handled by the justice system will be different, but it must at all times be responsive to the child's developmental stage. We have to look at the use of detention and the current challenge that we see in Africa of widespread detention of children. And last is legal aid and representation, especially when these children are accused of having transgressed the law. So as we go forward, I'm going to be addressing to what extent do our African justice systems put into place measures that address these key elements. So I will share with you approaches to improving a child-friendly justice system. And one, of course, we always start with the law because it provides the framework that then sets out the mechanisms for how children are dealt with by the law. And ideally, and this is really prescribed in the CRC and in the African Convention Charter on Children, is to have a consolidated law that covers all issues of children. But we see that even on the continent, all countries do not have this. Currently, we have 35 countries which have consolidated statutes on children. The importance of ensuring that laws are harmonized, laws that touch on civil administrative matters and policies are harmonized really with laws that affect children. The laws and policies, again, must be provided with a framework for implementation. A constant challenge on our continent because of limited resources, competing priorities, and sometimes lack of political will is that laws are established, but they're not implemented because the framework for implementation, the resources for implementation is lacking. And this is especially with those who are considered to be others. And I say others in terms of quotes, in terms of in the justice system and in national planning and policies. And in this case, I'm thinking of children being the others. In different countries, it will be different populations. And this is just a rundown, a list of the 35 countries that have statutes on children, consolidated statutes. I will not go through all of them, but just to give you a glance that we still have more than almost 17 countries still needing to advance their laws. So I want to go through areas where we can find gaps and where we find children can fall through the system when they come into contact with the justice system. And this is a way of then spotlighting how we can develop laws, policies, and programs that advance the rights of these children in contact with the justice system. And I don't want to speak much about the criminal justice system because that's what all of us think about when we hear of children and justice. We think of children who are accused as having transgressed the law. We think of children who've been convicted and have been sentenced. But I want to focus more on children who are victims of crimes and children who have been witnesses to crimes. But I will try to be well balanced. And I also want us to consider children who come into contact with the civil justice system with administrative procedures, which in many times even affect simple things like access to education, access to social services, birth registration, all these things. So administrative procedures are critical. Where are we as a continent and what more can we do? And I'll spend a bit of time because, as I said, at the African Child Policy Forum, we are very much aware of our context on the African continent, where customary courts and the informal justice system plays a very big role. It is accessible, it is cheap, it is it's quick, it's expedient, which we see is a key element. So we do find that a lot of children end up interacting with the informal justice systems, which really are based on values that are traditional and might not reflect the values and norms of human rights and of child rights as well. So I'm going to look a little bit at that as well. And I'm not going to go into the elements of why courts are not available. I think I will leave that for somebody else. Okay, so looking at procedural issues that we need to consider when we are then addressing the child friendliness of the justice system. We start first by saying, from a preventive approach, when it comes to children, we don't want to be reactive and responsive, but really when we think of human rights as promoting, protecting, and fulfilling rights, one of the ways of promoting rights is ensuring that we prevent, especially children, from coming into contact with certain elements of the justice system by ensuring a holistic, robust, integrated child protection and social systems. And that's why we are seeing, for instance, now during this time when of COVID, when we are seeing that social systems are extremely strained, child protection is low on the list of national priorities. We will find that more children will come into contact with the law, either as victims or as offenders. And the second element of prevention is not just in having the very, very robust protection and social systems, but in ensuring that all children can access them, that they are inclusive, that children who are on the move, refugees, IDPs, children with disabilities who are more vulnerable to abuse, orphans who are in huge numbers on the African continent. We've seen what Ebola has done. We've seen what HIV did, especially in sub-Saharan Africa in terms of orphans. So these are children who, to how extent does the justice system protect all of these children? Second is having laws that criminalize actions that are crimes against children. And here I want to provide very severe sanctions. And here I want to particularly draw your attention to where there are tensions between what is culturally acceptable in Africa, but what offends human rights norms and principles, what is not in the best interest of the child. And so I have used these three examples: corporal punishment, sexual exploitation, and sexual exploitation in the context of child marriage, and FGM, female genital mutilation, because these are issues which if left to an informal customary resolution, then you will find that principles and norms of justice first are not reflected, of child protection are not, of child's rights are not reflected, and lastly, of human rights as a whole are not reflected. And then there's also, in terms of procedures, there's the issues of arrest and alternatives to arrest, pre-trial alternatives to diversion, detention, both pre-trial, during trial, and post-sentencing, and safeguards during trial. And this is really in terms of the criminal justice system. I'm also thinking about the importance of us looking at what happens to children who have been offenders, who have now a criminal record, so to speak. What happens to them after release, after detention, and they have been released, in the elements of reintegration. How a child is brought back into the society is a key element of child friendliness justice system, because the justice system doesn't end at the point of punishment, detention, and rehabilitation. Rehabilitation goes on to encompass reintegration and picking up their lives and continuing after the justice issues have been resolved with. And I highlight that because we know very well that the reintegration element in the African context is, again, very little. We find that post-care, if I may call it that, after detention, post-detention care and services are minimal. So we do have legal policy and practice gaps in the criminal justice system, and these are the ones that prevent progress in developing child-friendly responses within the justice system. And for the purpose of this presentation, I will focus really on two. I will talk about the minimum age of criminal responsibility, and I will also touch a little bit on corporal punishment. So in terms of the minimum age of criminal responsibility, I think this graph speaks for itself. We have very clear recommendations that the minimum age should be 14. In as much as the CRC and the African Charter do not specify it, there have been the CRC general comments, the ACA, the Africa Committee on the Rights and Welfare of Children has actually aligned this to 15 years. But we find that we have more than 38 countries in Africa that prosecute children from as low as 7 years. When I look at Ethiopia, where ACPF is located, it's 9 years. And yet when we look at Senegal, which we might say is one of the countries which has made great advances in protection of children, 13 years is still not up to par. So what does it mean when a child of 7 years, 10 years, really is has to go through criminal justice process? So that is one of the areas where, when we talk about having laws that are harmonized with international and African standards, and that be one of the places where we can really advocate for reforms, this is really one of the places where we can start. I'll not go through this next slide in detail, but it's really to just highlight what the AU principles and guidelines on fair trials has actually defined on the African continent the minimum age of criminal responsibility at 15 years. And the Africa Committee on Rights and Welfare of the Children has actually gone on to adopt this age. So that is one of the areas where you and I, ACPF and other partners, can really do a lot of work. I'll skip to corporal punishment. Again, an area where we find children, the justice system is really quite contradicting. Because on one hand, you'll find there will be laws that protect children from all forms of abuse, neglect, and violations. But at the same time, within the same countries, you find corporal punishment is permitted. So you will see right now we only have 9 countries in Africa which outlaw corporal punishment. And I highlighted earlier in my presentation, the very difficult place for advocating against corporal punishment in an African environment, where when I grew up, you know, my mother could administer corporal punishment, my neighbor next door, and if I was caught, you know, going to the local market and have been considered to have, you know, committed a small, you know, misdemeanor, then even the woman at the market could, you know, give me a few slaps, punches, whatever she felt was necessary. So when we come from a place where children are raised by communities, how do we then, on the African continent, address the contradictions between our customs and cultures and human rights norms and principles? I hope you have looked further down on my slides to just see that there has been a bit more progress in terms of prohibiting corporal punishment in schools. But what we are really advocating for is more prohibitions in schools, but further prohibitions in all settings. I'll not go down. I will now move away from the criminal justice system and look at safeguards for child victims and witnesses, because this is one of the areas where oftentimes you find courts, especially the formal courts, civil justice, criminal justice, are caught unawares and flat-footed and do not know what to do with children when they come in as victims and witnesses of crimes. So in general, there needs to be more responsive procedures that bear in mind the previous elements that are highlighted of a child-friendly justice system. How do children give evidence? Is it by video? How is their privacy protected? How are children interviewed? And here we also need to think when children have disabilities, especially intellectual disabilities. And in my previous work, I have interacted a lot with girls with intellectual disabilities who are victims of repeated sexual violations simply because they could not communicate. So how are children such as these enabled to interact with the courts? How are they interviewed? What is the place of use of intermediaries for these children? How is their privacy and confidentiality safeguarded during the trial, but even afterwards in terms of how court documents are handled? The place of services, social services, psychosocial support, sometimes treatment for physical injuries, when for children who are victims, and sometimes for those who are witnesses and have psychological trauma, is also an area which needs to be invested in more so that we can have a system that is responsive. And if you will recall, when I started, I talked about prevention through social protection and social services. This is really what is important. It needs to be preventive, but at the same time, able to respond and to meet the needs of those children who have been victims and witnesses. And lastly, this is a challenge we have observed, the capacity of professionals to deal with children. You find senior court officials, judges, magistrates, senior counsels who do not appreciate the values and the norms of dealing with children. What does it mean when you say do no harm to a child? What is in the best interest of a child, both in criminal and civil cases, in matters even of guardianship? So how do we make sure that we build systems that really professionals are up to speed on what really is good practice as far as safeguarding children is concerned? So what does the civil justice system need to be friendly to children? And I will not go so much into some of these details, but I want to just highlight that the children in need of care require protection during judicial review, removal, or placement. And the reason I highlight this is because in many African countries, social workers working within the Department of Child Protection are able to remove children who are at threat. But what level of oversight is there? What level of supervision is there by the court systems? When it comes to disputes regarding care and access for children, again, this needs to be responsive, and this is where the element of child participation also comes in, and the best interest of the child. Guardianship, adoption, and unaccompanied children. Unaccompanied children are one of the areas where I think we could have a whole session on, because it enables us on the African continent to really think about refugees. And if I recall correctly, last year there was more than 25 million refugees globally. Those are if my mind serves me correct, UNHCR statistics actually talked about 25 million refugees, out of whom the majority were women and children. So if we think that those could be a possibility of millions of children who many times will be displaced, sometimes will be unaccompanied, sometimes will even be heading households, of other children. How do we ensure that the civil justice system responds to them? And this is especially in terms of administrative decisions. When they come in as asylum seekers, how does the system respond when these children have no adult who can represent their interests? just a minute, I want to go back a little bit on the issue of adoption and inter-country adoptions, simply because that is one of the areas that ACPF has done a lot of work on, and even convened a policy conference some years back on. What is the role of the courts when it comes to inter-country adoptions, and ensuring that such decisions are not made by lower courts or by any other institutions outside of the justice system? When it comes to all other matters that deal with families and children, even when they are resolved at much lower levels, at departments of children and child protection, this also needs to be supervised and by the courts, so that they can ensure that decisions are in line with the rules and the principles that are reflected in a child justice system. In guardianship matters, children who have been orphaned often do not have natural guardians, even natural legal guardians. And many face problems in winding up of an estate, even obtaining essential documents such as birth certificates, and accessing social services where they need parents to parental support to do that. And so courts can make orders of guardianship, but access to courts, as we said earlier, is a problem in many countries. So you find that these children without legal guardians are children who will often fall through the cracks, and they're the children who then will not be able to access education, access health, and even access other forms of legal protection. I have given a few examples here from Malawi, which is quite progressive in the sense that they have allowed guardianship matters to be handled by lower courts, which means it's more accessible, bearing in mind that the high courts are fewer in number and more difficult to access. But in Zimbabwe, which also is quite progressive in this area, however, we see that only high courts can deal with matters of guardianship. So when we are seeing progress, and it is important to have this legal oversight and by courts, on one hand, it can hamper, and on another, it can hamper access to justice for a child who must access a high court and is living in a remote village somewhere, not even Bulawayo. I don't know the remote villages in Zimbabwe, you'll forgive me. But a child living in a remote village. So also, where do we draw the balance in ensuring that the oversight is effective and does not become an impediment? And especially on the African continent, where we know that their courts might be one in a region, one in a province, or one in a district, or where we have circuit courts, which do not sit every day. On civil justice, just a small point on unaccompanied foreign children. And when I say foreign, I mean migrant children who may have an asylum claim, or some may also have been trafficked for purposes of work. How does the system respond to these children? How are they dealt with by authorities in the receiving countries? I want to quickly come to an area which I find very interesting and is very unique to us on the African continent, because there are a lot of tensions, contradictions, but also areas where there is a lot of similarity between the informal justice alternatives and the formal ones. And we find that the use of the customary courts is widespread. In fact, let's not call them courts, let's say customary justice systems. It is widespread and operates completely parallel to the formal justice system. But what have been the checks and balances? Has there been, is it regulated? Has it codified the principles and norms of human rights and justice, or even of child protection? And so at least partially recognized by the formal system, insofar as they do not breach the constitutional principles. And we do find that quite common. But also there needs to be included in the ambit of child-friendly justice to ensure compatibility with international and regional standards. Of course, the advantage is that these courts are accessible and they evolve, but we have to ensure that as they evolve and they continue to be developed, they evolve in a direction that is consistent with human rights norms. I have put there one short disadvantage. So child friendliness requires alternatives to judicial proceedings, and this is what I want to go through. Alternatives that serve the best interests of the child should be encouraged. They must not, justice systems must not be an obstacle to a child accessing justice. They need to explore also alternatives such as mediation, diversion, and alternative dispute resolution, so long as this reflects the the principles and norms of justice and human rights. Customary law options are also a viable option, and it is something that we cannot disregard. We have seen in Uganda attempts to codify some customary law, and this is really the direction in which we would be looking to advocate on the African continent. And all alternatives to court proceedings should guarantee basically legal safeguards and child safeguards. And the importance of seeing rolling out what we are seeing in Uganda is now something that is high on the agenda and is being discussed. And even this year, during the celebration of the Day of the African Child, it was identified as one of the areas where the trend in codifying customary law practices to ensure that they are consistent with the existing legal system is one of the things that the African Committee of Experts could focus on. I've touched a little bit on this. So in terms of what needs to be done for us to have progress, and I think I should be done in the next 2 or 3 slides, we need to see more passing of laws that are consistent with the African Charter on the Rights and Welfare of Children. And while that has happened, we need to ensure that these laws relate to all child offenders and all children in need of care and protection. That is the element of inclusivity. An increase in focus on child victims and witnesses, more legislation focusing on civil aspects beyond care and protection. And on the role of courts, case law now illustrates the court's growing awareness of key principles, such as the best interest of the child, even in areas where children appear in courts that are not specialized child courts. And so this is the case law that needs to be developed. And especially for you who are legal practitioners, this is one of the things that you can really do a lot to advance. There's need for accountability at all levels. And I stress again, the accountability also within the informal justice systems to ensure that they give effect to human rights norms and standards. When it comes to opportunities for improving child friendliness of justice systems, these are numerous really, but I will just highlight a few. Already we have guidelines on action for children in the justice system that were published by the AU, and we have general comments by the African Committee. So advocating and really ensuring that national level governments are able to adopt this is one of the things that ACPF has been working on. There is an opportunity in strengthening a systems approach that facilitates access to child rights comprehensively and to ensure that this can be applied to justice systems. A system that is responsive to the needs of all children in Africa, including the most vulnerable. When it comes to documentation of effective and practical models, this needs to happen more because when we interact with partners working in different countries on the continent, even in countries, post-conflict countries like Sierra Leone, you hear of models which they are introducing into their justice systems, which are new but are not documented and are not shared. So there needs to be more concerted efforts in documenting some of these practical models so that they can then be rolled out onto other countries on the continent. And these are models addressing issues such as using detention as a last resort, pretrial diversion. We need to also maximize on the existence, use, and role of indigenous and informal justice systems, mechanisms, and solutions, of course, ensuring that they are aligned to the norm, the values and the principles that we uphold. And to regulate the interaction of these systems with children by codifying to ensure codification that will ensure the principles of child systems are reflected. Ladies and gentlemen, I've come to the end of my presentation, and I've shared with you a list of few resources that ACPF has worked on together with other partners that you might find useful. And thank you very much. And I think I'll hand over to you, Thoko, so that we can have a good discussion now. Thank you.
Okay, many thanks, Joan, for these insightful observations on child-friendly justice systems. I think as host, I'll abuse my privilege and have my question as the first question, and then I'll invite others that are with us this afternoon to join the discussion. I have a very simple question that relates to the role of indigenous justice institutions in making child justice systems better and more effective, both in relation to the civil as well as the criminal aspects of justice. And I just want you to share your observations about how these indigenous systems that are often labeled as informal systems can help in this development. I think perhaps it might be better if you take a couple of questions and then answer them together in that way. I see here on the chat that Tanu and Jonas would like to also ask. Tanu may ask if you can ask one of your most pressing questions. We can come back to you in another round. And then Jonas, if you could follow Tanu. And then John is going to address our questions. Thank you.
Yeah, thank you. Thank you very much, Ms. Nyanyuki. It was, yeah, I learned a lot from your talk. And I would, I have 3 questions, but I just asked the first one and hopefully I'm brought into another round to ask the follow-ups. Do you find that a child-friendly justice system would imply changing our approach to how we understand human rights itself? Yeah. Thank you.
Thank you, Jonas.
Okay, thank you.
Okay, you hear me, right?
Yes.
Okay, thank you so much for your interesting presentation. And I got a couple of questions. The first one is, there is an emerging jurisprudence that says that corporal punishments are part of this torture, but the traditional framework is corporal punishments are an independent crime. But there is the jurisprudence indicates that there should be an integrated legal framework so that a very good emphasis should be given for corporal punishment as torture in terms of its gravity. So how is your approach or your campaign toward this incorporating corporal punishment as part and parcel of crimes of torture or as elements of torture in order to maximize the punishment or the sentence, which is crucial in my opinion? The second question is, with the coming into a picture of this pandemic, the number of abuse and rape, child abuse are increasing. Even I am from Ethiopia, and I know this issue has been a point of discussion for different parts of the people. But the question is, there are some trends of or some acts of rape by family members, which are usually neglected. For instance, father can rape his children, or a boy or a girl, it doesn't matter. So the issue of access to justice in relation to attack or where the perpetrator is a family member is very improbable or very difficult, because even the mother would not like to expose herself to the community. There is shame issues. So how do you address these issues? The second issue in relation with this is, for instance, the issue of this crime against nature are rising here. So some people do not want to campaign the rape of boy as grave as the rape of girl, because the rape of a boy is sometimes linked with these issues of right to LGBT, which is emerging issue. So boy victims are less treated in terms of access to justice. So how do you approach those issues? Because it's been a point of discussion in Ethiopia about those stuff. That's why I'm asking. So those are my questions. Thanks so much.
All right. Thanks for all your questions. And I'll start with the last ones. Jonas, my brother from Ethiopia, and thank you for hosting ACPF in your country. In terms of emerging jurisprudence, and in my introduction, if you remember, Thoko talked about my work in working with victims of torture. Actually, I started my work as a medical doctor. Oh, I am no doctorate in law, I should have said that. I started my work in medicine, and I got into human rights because of examining torture victims and preparing forensic medical reports that then were used in court processes. And so when you talk about corporal punishment as a form of torture, on an individual level, I completely agree with that. In fact, I was very excited to see, and you're talking about emerging jurisprudence, to see even the Committee Against Torture in some of its comments, and some of its comments when it reviews country reports, actually stating things like FGM are actually amount to torture. Violence against women is torture. So in my view, violence against children, especially when it is done within a legal framework where corporal punishment is legalized, really amounts to torture. And I think that's where when I would actually throw a challenge to those who are involved in strategic litigation, those who are involved in reporting to those committees where you can bring individual complaints, to challenge these committees and to challenge courts to get to the point where we develop case law that corporal punishment is a form of torture, and torture against really the most helpless. And on the continent, we have seen numerous children, corporal punishment administered to the point of death. It is even happening now with COVID, with children being locked at home. So I completely agree with you that if it can get to the place where it is recognized as a crime equivalent in severity as torture, then we would be able to advocate for severe penalties. Because one of the things, when I talked about the point of criminalizing actions against children, when they're criminalized, then we can go for penalties and go for very high penalties, which will be deterrent to others. As ACPF, we haven't focused specifically on a full project on corporal punishment, but I do know there are partners who are working on this, though they are UK-based partners, and they have been working actually towards the ends of making sure that even where it is not outlawed, there are at least administrative guidelines that at least prohibit it. So on the continent, I think it's going to be very difficult, Jonas, and this is a debate. Oh, I forgot to mute my phone. Sorry. This is a debate that we've had with colleagues in terms of what is the most pressing priority for African children. And it does disturb me when we start talking about the right to food and the right to education being more of a priority, where we should be investing our energies, and saying that corporal punishment is no longer a priority, because we know all are indivisible. So if we advocate for these rights, knowing that it's one package, then we can do more towards really work on corporal punishment. And in the global partnership to end violence against children, where ACPF sits as an executive committee member, one of the things, there's a whole program on violence against children. And one of the things that I've been pushing is, can we have corporal punishment high on the list of the agenda, the same way online violence is high on the agenda? And for us as ACPF, we try very much to setting the global agenda on children to make sure that it represents the African child. Because if you look at online violence against children, the number of African children who are at risk of that is much lower than the number of African children at risk of corporal punishment. So it doesn't negate that online violence is an issue, but if I have to raise my voice, I want to raise it first on that affects the biggest number of children. But again, it's work in progress. And I know time is short and I have many questions, so I will end my comment on that one. In terms of, yes, sexual violence in families, and really how this is addressed in terms of children as this accessing justice. again, I said earlier in my presentation that I want to focus on children as victims and witnesses, because that's where their rights are completely forgotten. And these matters are resolved before coming even to the court system. I mean, there is, what do they call it? They pay blood money, or they give a few goats and a few sheep, and the matter is resolved. So for us as advocates on the rights of children, I think it's two levels. We have the laws in many of these countries, even in Ethiopia, where you're talking about this, and I have seen those cases in the recent months. The laws are there, but community attitude and practice. And on the African continent, these two must really go together. That we need to create a demand for human rights. Because so long as there's no demand at the family level, so long as the mother is not outraged and feels she should cover for her husband because of the shame and the stigma, there is no demand for justice. So we need to create a supply. So making sure that the court system is friendly. So we are supplying the human rights, if we can call it that, supply the justice, but at the same time, think of it as who is going to demand for it? Because we can set up all these structures, all these mechanisms, all these procedures, but the community awareness is not there. Community tolerance and acceptance of corporal punishment, of rape of boys, of incest is becomes the biggest challenge. So even in our policy advocacy, we have to get to the place where we are seeing policies are not simply about setting up systems, but setting up systems that engage with communities so that we can then make sure that supply and demand come together. And I think I've addressed your issue on boys, and especially as somebody who is very passionate about the rights of women and children, I completely agree that boys have really been put on the side, especially when it comes to crimes of sexual violence crimes and abuses. But I think again, it comes, in my view, the law provides the protection in many countries where there are laws on sexual violence. But it comes back to, again, the demand for justice for boys and the shame and the stigma. How do we address that and how do we approach it? And here, yeah, I completely hear you on the confusion with LGBTI issues, and it becomes more complicated and more complex. But I think we have to go back to the elements of child protection, where we are talking of, not child protection, of a justice-friendly system, where we are talking about things like simple child participation, child safety. How do we make sure that even these boys, when they come as victims and witnesses, they don't become, they're not mocked, because in some of these communities, a boy who has been, sexually violated afterwards is called a girl, is called a woman, and the level of being ostracized in community. So how do we make sure that even within the court system, there are safeguards, so the identity and privacy of this child is protected, so that then they are more able to go. I want to add a comment of my own, in that in as much as we are advocating as ACPF for codification of customary law, this is only to the extent where it does not contravene human rights norms and principles. And certain crimes cannot really be adjudicated or resolved in the informal justice system, such as sexual violence. So there also has to be guardianship matters can be resolved and then supervised, by the courts, but some things like criminal acts such as of sexual violence, really those should never be left to the informal justice system, and hence the importance of codification, because once we have clear guidelines that are in line with the constitutions of countries, that are in line with instruments, charters, and conventions that countries have ascended to and adopted, then there will be no contradiction. Then the codification will take away the contradictions, and those will be then addressed effectively. I want to go to so that's my answers for you. Jonas, I want to go to Tanu's question. Child-friendly justice system. Okay, this is my own opinion, but I don't think there's any contradiction between having a child-friendly justice system and my current understanding of human rights. In fact, I think they come together. And I'm thinking of really the origin and the thinking of human rights. And the thinking was that at the time of the UDHR, that the thinking then was that one instrument was going to be adequate to safeguard everybody's rights. But as time has gone on, we have seen it has not been adequate. So when we talk about child rights and all other elements that come out of it, in I have a strong conviction that these are only emanating from the principles embodied in the Universal Declaration of Human Rights. So it doesn't need to change how we think about it. We just need to ensure that it's all humans and it's all rights. Once we go back to those basic principles, then all humans, all rights, protect, promote, fulfill, inclusion, no discrimination, then we can actually see that even a child-friendly justice system actually is a way of living those very human rights principles. That's my own conviction. I do not see it changing in any way. In fact, I see it more advancing and developing the emerging jurisprudence and new thinking to just be responsive to where the world is now compared to where it was, 60, 70 years ago. I want to come to Thoko, your question. Can I remember it? How can it? Okay. And this is really about traditional justice system. Perhaps I touched a little bit on it, but how I think it can make it more effective is, I think we always say justice delayed is justice denied. If everybody's right to speak up in a court of law, some of these principles of justice have almost become a common talk, that everybody has a right to speak up and defend themselves. Say it now or hold your peace. So I think the traditional justice system makes all those things more accessible, more affordable, more time sensitive and responsive. So it can definitely make justice more accessible. However, again, I'll repeat the caveat that there are certain criminal matters that really cannot be left to the traditional justice system. And for me, I feel in the issues of children very strongly about the issues of sexual violence. That's really one of those that should not be left to the traditional justice system. But if we can really work very hard towards ensuring that first the very principle of the very principles of the African, and I don't know how to put this, the principles that Africans hold, use the word Ubuntu, oneness, caring for your brother, where like now, Jonas is my brother, Thoko, Tanu, everybody is my sister, my brother. If we can really apply those principles even to criminal matters, where you look out for the weakest of your brothers when they have been abused or violated by the more powerful one or by another brother, you will want justice. The only problem is that oftentimes the people who make decisions in these informal justice systems are the very people who hold all the power and maybe the transgressors. So you find that conflict. Women don't even sit in these panels or benches, if I can call them that. So I think that's where my concerns would be. How do we make sure that we advance and develop traditional justice system to evolve where it can provide justice, but with very clear caps and limitations, especially when it comes to the criminal justice system. Civil and administrative, I would be more comfortable with that. But on the criminal elements, there has to be very strict limitations of the authority, strict regulation, and even monitoring and reporting. I will pass the mic back to you, Thoko, to moderate another round of questions.
Okay, all right. Thank you for your insights on these questions, John. I'm looking at the time now, and I think we should be able to take one or more, two questions, and then you can have some final remarks of your own, and then we can close our discussion this afternoon. We have here a question from Mumbanika, and then another one from Hassan. Do you want to start off, Mumbanika? I'm sure I'm murdering your name right now. And then Hassan, with your question, and then John can respond to these two questions, and then we close. Thank you. Turn on your mic, please. Thank you.
Okay, do I go first? Hello.
Yes.
Yes, go ahead.
Okay, thank you, Dr. Nyanyuki, for the insightful presentation. I really enjoyed it. Just one question. My background is not in legal studies. I'm in religious studies, and I'm just curious. I want to, if you could shed some light on what is the role of the religious courts. And here I'm referring to the Kadhi courts, for example, in Kenya, in advancing child-friendly justice system, given that there are some aspects of the Kadhi courts legal system that are found to be problematic to the fundamental basic human rights. Thank you. Thank you.
Another question, then I can answer at least 2 or 3 together.
I'll ask the question on his behalf, and he's asking how friendly is is child justice at the African continental level. So perhaps looking at the mechanisms we have at the African Union, but also the African human rights system. How, I mean, what are your perspectives on the friendliness of these mechanisms? Okay, thank you.
All right, thanks, Hassan, for your question. And I think when we talk about the tensions between the alternative justice systems, we cannot disregard the religious ones. And thanks for bringing that into this conversation. Because again, there will be places where there will be contradictions and tensions, but there will be places where there will be synergies and complementarity. And so I think on issues of especially on issues of families, whether it's children, parentship, guardianship, marriages, there are lots of contradictions. And so when you ask, can these religious courts advance child justice? I believe they can. And in a country such as Kenya, and this is where I have the benefit of being a Kenyan national, is these are recognized within the Constitution. And therefore, having been recognized with the Constitution, they are bound to really adhere with the principles of the Constitution. I mean, and they operate in Kenya, so they have to adhere with those principles. And so even where there are contradictions, yes, they are problematic because there is contradictions with basic human rights principles. And while I do not have an answer, because this also happens in issues of divorce, in issues of marriage, even in issues of domestic violence, we do hear these contradictions. I've seen that, especially now, there has been more efforts to try and strike a balance somewhat. And I don't speak as a Muslim, I speak as an observer, to find a balance between what the Kadhi courts provide for, but also what the other higher courts provide for. And I do know also that some of these matters can go to appeal to higher court. I would actually look at it as it's not a measure of last resort. None of these alternative justice systems are measures of last resort, be they traditional or be they Kadhi courts. They are really places where those who are in conflict with the law or those who have been violated will go, but they have the opportunity really to still seek higher elements of more redress and remedies. So yes, there are contradictions, but I think it starts from a place of being aware that there are contradictions, and then for you, especially for those who are advocates and lawyers and practicing in some of these systems, to really see how do you ensure that the rights of children are still upheld. How friendly is the justice system in Africa? A couple of years ago, I think it was it could have been maybe 2012 or 2014. One of the reports that I shared in my list of resources was published after a research by ACPF. And what it found is that there have been steps, progressive steps towards making the justice systems responsive, sensitive, accessible, for children. However, there is still a lot to be done. When we think of the provisions at AU level, they are very clear in terms of what they're talking about, and the simple examples that I have given in this discussion. The AU is very clear. The general comments of the Africa Committee on the Rights and Welfare of Children are very progressive. In some regions, such as SADC and East Africa Community, they even have child protection policies, which all members have signed on to. And part of those elements actually speak about redress for children, for instance, who've been trafficked, when crimes happen in their territories. So there is recognition, but the gap is actually between the legal framework and the practice, somewhere in between there. And it comes to the issue of priorities, political will, and resourcing. So we need to advocate, yes, for laws where they do not exist, and for implementations of the recommendations by the African Union and its structures. We need to advocate for both of those, but at the same time, we need to advocate for implementation. These laws, these policies have to be turned into practice. And one of the things that countries are now beginning to do is to develop as child protection that brings together all key players. So you're finding, I have seen, actually, and I'll use the example from Ethiopia because we have been involved in it, of having a child policy that brings together not just child protection, but all social services. And in that, actually, the Supreme Court has been involved. So when you bring in judicial actors who can offer legal protection and legal remedies, and you bring them into elements of actually developing and designing a child protection and social services, then you're more likely to make more progress. So that's one example I can use for Ethiopia that has been more progressive. But also we have seen wide discrepancies in countries. You'll find countries which in one area, for instance, are doing very well, providing education. But when it comes to the justice system, then they fall back and do not do as well. So it's difficult for me to tell you how friendly is Africa in terms of child justice. What I can simply say is there has been progress, but more needs to be done in terms of harmonizing the laws and in terms of ensuring practice of existing laws and policies. Thank you. Soko, back to you.
Okay, thank you. Thank you so much, Joan. And we are very grateful this afternoon that you were able to make the time to be with us. I know that it hasn't been so easy to connect, but I'm happy that eventually we were able to agree on a slot that worked for the both of us. And as you're back home in Kenya, we wish you all the best. Have a good time with your family. And to everyone else that joined us in this debate this afternoon, I'd like to thank you for making time. This will be published on our various websites, but also if you have questions that follow on from themes that were raised, do get in touch with Joan. She'll be more than happy to engage on that.
Oh, yes.
I'm going to stay on the call after this, and Joan, I would like to ask if you could as well for some more informal discussions, maybe for another 5 minutes or so. But I would like to invite everyone to give just a thumbs up of thank you as we do on Zoom to Joan for making time for us. Thank you so much. And Professor Banda, may I ask you to stay on the call as well as we close. Thank you. Okay.
Oh, I can see the thumbs up.
Yes.
Thank you very much. And really, it's been a pleasure. It's been a pleasure. It's always nice to interact with people, and especially now when the opportunities have become, fewer.
Yes.
Really, thank you for this, and thank you for a very interactive audience. Yes,
Yeah.
I've enjoyed it. Yes.
Okay.
And happy to reach out. What do I say? I'm on LinkedIn and I'm on Twitter using my names. You can find me easily. Yeah, if you have any question. Yeah.
Okay.
And maybe Toko, I should just say in the presence of your of everybody that we are actually looking at Africa Child Policy Forum. Now we are looking at we have developed a child friendliness index. And we have used that for the last 12 years, actually, since 2008. And we use it to measure different elements of how responsive is a government to children, how friendly is a government to its children. And so the question that was asked by, who was it? Mumbanika, actually makes me think that maybe that should be a thing for one of our reports. You know, we should actually adopt that index to measure how friendly are African governments to children in terms of justice, you know, child friendliness. This year, and I'm giving you a leak, we are looking at child friendliness to girls. And so later I will be inviting you for that. We'll be launching in November. In the past, we've looked at friendliness, you know, different elements of government friendliness. But now we can actually come and I'm just thinking that that's something worth looking at, actually measuring it. And it's done in a very scientific way. The people who crunch numbers, statisticians and economists, they develop formulas, and I don't understand them. They go over the top of my head, but it really makes sense at the end when they give you that report. So I'll be happy to share what to do this year, but also to ask my team, can we sit down and think about measuring child friendliness justice? It's a very good outcome for me from this meeting. Thank you.
Okay, no, I agree with you entirely. And as you were speaking, I was just thinking about, you know, the landscape of justice for African children, and that a lot of their interactions in the community are going to be with these indigenous justice institutions. And you spoke about the issue of harmonization, and it's all and good to raise the questions about how you know, why it's important to undertake such harmonization engagements. But how do we do this? And this is a question that I've asked throughout my career, and I still don't have very good questions. And I wanted to know from your experience as a medical doctor and a human rights advocate, I mean, how do you see the processes of doing this well, but also in a sustainable way?
Yeah, it's honestly very challenging, but you know, I want to simply look at a few examples we've seen more in transitional justice. When you look at the Gacaca courts in Rwanda, after, you know, as ICTR was sitting, there was also the, you know, the alternative, the Gacaca courts. In Sierra Leone, again, even after their, you know, decades of war, I came across something called Fambul Talks somewhere. This is, yeah, the Fambul Talks. And, you know, it's really around a fire and these confessions, you know, so it's restorative justice, you know, and the people would confess, same principles, you know, you confess, and then there's forgiveness, and, you know, whatever, and whether or not forgiveness, I mean, there has been criticisms of all these, you know, African justice, indigenous, as you call them, justice systems. But if I look at some of those, like the Gacaca ones had even classifications. I think there was from 1, 2, 3 to 4, isn't it? Yeah. And there was restrictions at level 1, who could handle what, level 2, who could handle what the different Gacaca sittings could handle. And so that was an attempt, I guess, to sort of harmonize and to say these are issues for the lower indigenous Gacaca court. Then there was a mid-level and there was a higher one. And so I'm thinking perhaps that's how we can begin to harmonize. So if it's an issue of I cut your, you know, I cut down your banana. I come from a banana growing area. You know, I cut down your banana and people steal bananas, you know? So you have a banana, it's ready for harvesting, you're waiting, you've supported the tree, you know, with the sticks, the big sticks, it doesn't fall over. And you wake up in the morning and your banana is gone. You know, and you know the neighbor who stole your banana. So that's an issue that can be handled at baseline indigenous level. But if it's the other one where, if we think of it as something that is much higher, somebody came to your homestead, and I don't want to use something criminal like they burnt, but they stole, they assaulted. So they assaulted your child. a physical assault of your child, and a severe caused grievous harm. Is that something that can be resolved by the high Supreme Court of the indigenous system? And if the person is not satisfied with the outcome, can they still then go to the formal justice system? So I think harmonizing is also acknowledging that there are different crimes of different gravity. And I like the question Jonas asked, because corporal punishment is one good example. Where would you classify that? Is that a less grievous crime? Is it an assault? Is it equivalent to torture? So where would we place it? So I think harmonization would ensure that corporal punishment, for instance, is never left to an indigenous system. Sexual violence is never left. Child marriage is never left. Yet we see in reality, child marriage is being resolved in fact, not even child marriage, rape of children, which then the penalty to the perpetrator is marry the girl. And if a mother is opposed to that marriage, she can only go to an indigenous court where, men who are the age of her grandfather are sitting. So I'm looking at all these things and how complex they are. So some simply should not be left there. But I also want to say that, and I say this as a strong women's rights advocate, there has to be women and all other people sitting on those benches, traditional benches. Because if that doesn't happen, and that was one of the things with the Gacaca courts, it was not men only who decided. It was not men who only led those sittings. There were attempts to represent some of the human rights principles in terms of, when you talk about a fair hearing and there's no bias from the bench, what does that mean? It means in the traditional system that if a woman comes on an issue of child marriage and men the age of my father are sitting, I stand no chance. So how do you make sure that it's representative wholly, even in the people who make decisions? There's a lot. I don't know.
Okay.
There's a lot.
All right,
So
Joan, I would like to introduce you to my mother from Zimbabwe, Farida Banda, who was my doctoral supervisor. She's responsible for most of what I know in relation to the law and my approach to how law works in society. Ma, are you there?
I'm here. I am here.
Okay, all right.
I'm
I'm sorry for ambushing you, but I thought I should introduce you. So Farida is a professor at the School of Oriental and African Studies at the University of London. And like I said, she supervised my PhD, and I just wanted to invite her to say a few remarks about the topic of the day.
Oh, thank you.
I loved your paper. Thank you, Toko. He's my best student ever. I adored him, and I was so sorry to see him go. I miss him still. He was just so easy and so good. He was really smart, and I'm really proud of him. And I really liked your paper your talk on many levels, because I think what you were talking about in terms of violence and the best interest of the child reminds me of a CEDAW case, the Committee on the Elimination of All Forms of Discrimination Against Women. And it's a case against Spain, and it's called Gonzalez. So Gonzalez Carreno, it's Gonzalez against Spain. And what that was about was actually, it started off as a custody case and ended up being a violence case. So a couple were together. He was persistently violent throughout the relationship. They eventually broke up. She said to the courts, please don't give him unsupervised access or contact with the child. Initially, he had supervised contact, and then he kept being very good in court. And so they gave him day contact, and then they gave him weekend contact. One day, the child doesn't come home, the police are called, he's killed the dog and he's killed the child. And so the case was brought by an organization I've worked with called Women's Link in Madrid. And one of the things I suggested to them in terms of their bringing the case to the committee, the CEDAW committee, is in English law. I sometimes teach English family law. So in Section 31 of the English Children's Act, we have a provision that says the witnessing of violence by a child can itself constitute significant harm to the child. So one of the arguments I said that they should try and run, and I think it was successful, was that it was never in the child's best interest to continue to see this father unsupervised. Because the way the system was framed was, he's been a terrible husband, but that doesn't mean he's been a bad father. But if the witnessing of the violence constitutes a harm to the child, you know, what you were saying about witnessing violence or being or seeing violence. And what I like about the case is it takes it from this conflict between parents and refocuses the attention on the best interest of the child. And so that's one way. And the other thing that's been really good, and in terms of, I know you're advocacy people, so this might be helpful as well, is that the Spanish Supreme Court then took up the case and said that the recommendations that were made at treaty level had to be implemented within the domestic, because usually their recommendations, and courts, I mean, and countries or states often just say, yes, we'll do it and never bother. And there's very little that the committee can do to enforce it. So the fact that the domestic jurisdiction, the highest court said, no, you have to enforce it, I think was a very helpful thing. The other thing I was wondering about when you were talking and you mentioned the Committee on the Rights and Welfare of the Child, I think they're doing really, really well. And I wondered, well, in terms of jurisprudence, I mean, I think they went from not doing very much to producing jurisprudence. So I think there's something to point to now, whereas in the old days you couldn't. And so you identified the first general comment, which is on children and imprisoned mothers. So how do you think that works out? You know, if you could unpack or make the links for me a little more explicitly, I'd really appreciate that. But I loved your paper, thank you.
Thank you, Farida, and really thank you for sharing that case, because you know it really just shows how interrelated all these things are. I think in terms of the journal comments, sorry, I'll not be in a position to share that with you. I'll have to go back to my notes and check that, and perhaps we can have a separate conversation to just see, and I can probably check with my one of my legal team to see what else has evolved after that general comment. And if I can get your email from FOCO, I can come back to you on that. I'm happy to do that.
Okay,
yes,
great.
But I'm not in a position to do it right away.
Thank you.
Okay, you're welcome. Thank you. Okay. Lovely to meet you, Dr. Farida.
Great to meet you too. That was fabulous. The doctor who's a lawyer as well. Most of us become lawyers because we could never do sciences.
Yes.
So we had the option.
Okay, all right.
Okay. Great.
Okay, so I guess we call it an afternoon, and we have talked you out, and I'm just grateful for this opportunity, and we will be speaking quite soon. Okay.
Yes,
and
thank you very much.
Yeah, I'll say my goodbyes now. Okay.
Thank you. Bye.
Okay. Okay. Bye bye.
Asante. Bye bye.